Pessoal, bom dia, boa tarde aqui na Europa, bom dia aí no Brasil. Sou Jamil Chad para mais uma edição do Cruzando Fronteiras aqui no canal My News. E hoje, claro, com um convidado bastante especial, um convidado estrangeiro, um dos membros do Comitê de Direitos Humanos da ONU, que nesta semana tomou uma decisão bastante importante em relação à Operação Lava Jato no Brasil e ao ex-juiz Sérgio Moro. A decisão concluiu, basicamente, que Moro foi parcial em suas decisões em relação ao ex-presidente Lula. Também indicou que Lula, ao não poder ser candidato em 2018, teve os seus direitos violados, os seus direitos políticos violados. Uma decisão que é tomada 6 anos depois do início do processo aqui em Genebra. E para conversar justamente sobre essa decisão, nós temos como convidado o senhor Arif Bulkan, que é um dos membros do Comitê de Direitos Humanos e é uma das pessoas responsáveis justamente por essa decisão. Mr. Bulkan, before we start, thank you for accepting our invitation. It's a pleasure to have you here with us. And my first question is basically a very simple one, but obviously with a very complicated answer probably. What are the main conclusions you have reached after 6 years that this process is going on at the Human Rights Committee? Thank you, sir.
Well, thank you for soliciting a comment from the committee. And I note you mentioned the time, 6 years, but please note that the committee deals with communications from, over 100 state parties. So this explains perhaps why the line seems long. But our main conclusions in this particular communication brought by former President Da Silva was that the state party, that is Brazil, we found violations, several rights under the covenant, the ICCPR. And perhaps I should just list the violations that we found. We found violations established of the protection of liberty, the right to privacy, the right to a fair trial before an impartial court, the right to presumption of innocence, and his political rights, which is specifically the right to run for office and to vote. I can explain for you the reasons why we found these violations, if you like.
Yes, that would be very interesting, especially if you could go one by one. That would be very useful for us as well to understand the purpose of these decisions.
First of all, the claim was founded in the treaty which we administer, and that's the International Covenant on Civil and Political Rights. And it's the preeminent universal treaty on human rights, and it guarantees a range of civil rights. And so what the content of the decision focused on those 5 rights that I mentioned. The first, liberty. Now, obviously, liberty is not an absolute right. Individuals can have their restricted by the state, but the preeminent condition for this is that if any individual is deprived of their liberty, then it must be under procedures that are lawful. It must be guaranteed by law. And the basis of our decision to find a violation of this right was that really rooted in Brazilian law, in that search, the arrest warrant that was issued against the former president was issued without the criteria being satisfied. So in the first, we found a violation of liberty because the arrest warrant was issued without satisfying the criteria in the domestic law. Secondly, the right to privacy. Now, the basis of the violations there were rooted in wiretaps that were made, first of all, of conversations between the author, and by the author I mean the former president. So they tapped into conversations between him and his attorney, and I'm sure you will appreciate that conversations between somebody who's accused of a crime and their attorney are really sacrosanct. They go to the heart of being able to mount your defense. Yet, even though the investigating authorities had been alerted to this, wiretaps were approved of conversations between the former president and his lawyer. Then you also had wiretaps that continued even after the lawful authority had expired. And then you had disclosures of those conversations. And in fact, the Supreme Court of Brazil even felt that some of those disclosures were selective. In other words, you disclose part but withhold part to create a particular impression. So because of the nature of the wiretaps, the fact that some were done without authority, and the disclosures, we found a violation of his right to privacy. In terms of impartiality, that's Article 14 of the Covenant, which says, and you would appreciate, sir, that this is a basic right. Article 14 says that every person who is charged with a crime must have a fair trial before an independent and impartial tribunal. That led us to a finding that this right was violated. And some of it was actually based on facts that had been accepted already by the judiciary. And perhaps I could point out some of them. It was, for instance, the judge not following the Brazilian procedures before issuing an arrest warrant. There was an instance that was mentioned in the case where after the former president's conviction, he appealed. And so in a standard way, he applied pending his appeal. And he actually applied to the court, and the judge at the time in the court ordered his release from prison. And it turns out that the judge who convicted him, who was then on vacation, telephoned the prison and overrode the judge who said that he should be released. And there were public statements. And in fact, we looked at the Supreme Court of Brazil as well, which found 7 factors dealing with the judge who convicted him, which included all of these factors here. And for these reasons, we found that there was a violation of Article 14.1, specifically that he did not have an impartial court. In terms of presumption of innocence, this is a basic procedure. If you are charged with a crime, you must be presumed to be innocent. Disprove your guilt. There must be you mustn't be tried in public. You must be tried in a court of law. And we have standard jurisprudence that says, prosecutors and judges must not try the case in public. Yet what happened in this instance was that prosecutors gave very long, involved press conferences. There were book tours. There were lots of public statements in which the defendant, who was the former president, was painted as guilty, and there were statements about his guilt. And so for that reason, we found that there was a violation of his presumption of innocence. And finally, the last one is Article 25B, and that speaks to his political rights, the right to vote and to run for office. And because we found those violations of due process, those guarantees, those procedural guarantees, we then found his denying him the ability to run for office in 2018 constituted a violation of his rights under 25B, sorry.
Excellent, sir. One question regarding this behavior by the justice in Brazil, at least one part of it. How much does it harm the fight against corruption? In the sense that obviously corruption everywhere, not only in Brazil, but everywhere, is obviously something that has to be fought against. But at the same time, how to balance this fight against corruption with the rule of law?
Yes, I think a very pertinent question, if I may. What I would say, first of all, I do want to be a little cautious in the way you framed it, because really, I wouldn't want this to be seen as an indictment of the Brazilian judicial system. Quite the contrary. In fact, the Supreme Court ultimately found that there were instances of impartiality, and that the judge who convicted him was not impartial. So this was a finding of the Brazilian domestic system at the outset. And so I think it tells us that overall the Brazilian system is, certainly the institution, does seem to be strong. But in terms of your larger question about how does our ruling impact upon this, I would say I think we have to look at it in totality. And I agree with you completely that the Human Rights Committee often says to state parties that you must investigate corruption. You have a duty to do this because corrupt acts actually impact upon people's human rights once money is diverted. So we are not wavering from that. But I think the point that we want to say is that when states engage in this fight against corruption, when states investigate acts against corruption, when they bring persons to trial for corruption, no matter who they are, how high or low you are, every defendant must be treated the same way. And specifically what that means is that all of the procedural guarantees of a fair trial must be respected. And those procedures exist in Brazilian law, but they are also contained in the Covenant, Article 14, and others. And so our simple message is that these due process rights, as they are known, must be respected so that everyone has a fair trial.
Fantastic. Basically, on that point, former President Lula had a situation where he was for over 500 days in prison. You mentioned all of this in your very thorough report. Today, he is free and he can run for president. This decision obviously is a very important one, but how to reestablish or remediate whatever happened to him in the past? What is your recommendation in that sense? Is there any way to, in a way, I'm not saying to compensate, but absolutely to deal with that injustice that, according to you, was done?
So, the committee, being an international tribunal, there are limits to how much the committee can order and what it can actually impose upon state parties. So generally, once we make a finding of a violation, we often order the state to make adequate reparations. And in this instance, the remedy that was awarded to the former president was precise by the committee to say that the state should provide adequate reparation. Notice it's given in quite general terms. So in other words, it leaves it to the discretion of the national authorities to determine what reparation that would be. But obviously, some of this occurred in the past. Some of it is imprisonment. You don't get back that time. And of course, because of the ruling of the court in 2018, he could not stand for elections then as he would. But all of that is in the past. So we simply ask that reparations be provided, but leave that to the discretion of the state. The other remedy that was awarded was to, and again, this is quite standard, to ask that the state party ensure that if there are any future proceedings against him, or continuing procedures, that they simply respect Article 14, the due process requirements. But again, this is quite general. In other words, these are the kinds of remedies that we would often award.
So in 2018, cautionary measures were taken in this case.
Yes.
And in Brazil, they were ignored. If the state repeats itself and in a way ignores your recommendations and your decision, what kind of violation will Brazil be committing, or what is the message Brazil will send if it again ignores the decision?
So the decision is not. I mean, I think first of all, the force of the decision, I think, is very much in the finding of a violation. That in itself, that articulation, I think, ought to carry some weight. So simply the declaration saying that these violations occurred. And I should say that there's nothing extraordinary about it, because much of it is rooted in what the Supreme Court itself had found last year in the final decisions in relation to this case, and in relation to the conduct of the judge who convicted him. So the articulation of this, the declaration itself, I think carries some amount of moral weight, I should say. And in terms of the specifics, all that the committee asks that the state party do really is to ensure non-repetition, to make sure that because really what the Supreme Court said is that they had no jurisdiction to try him, but that doesn't say that he cannot be tried again in where the jurisdiction, in the state which has jurisdiction. So that's the basis of the committee's remedy, which says if you try him again, then please respect all of the procedural guarantees. But what I could add is that that the committee normally transmits this to the state party, and then they have usually it's 180 days in which to implement. So in this case, to provide whatever reparation they deem fit. And, this is also a process in which, has to be carried out in some amount of good faith, because it's an international tribunal, right? It's an international tribunal that has, that in which the state party has entered into good faith and says, well, we are going to implement, we are going to accept this jurisdiction. And so by extension, agrees to cooperate with any kinds of rulings. Now, in terms of monitoring that ruling, the committee has a process in which, as I said, asks the state party to report within 180 days. And if there's no action in that time, the case is open. It's kept open, and there's what we call a follow-up procedure in which we enter into dialogue with the state to see how best they can implement the decision. But again, let me stress that, in this particular instance, what the committee is asking the state to do is something that Brazil as a democracy would ordinarily do anyway, which is respect the human rights of persons who are charged.
Absolutely. So one of the elements you mentioned was basically the behavior of the former judge, Sergio Moro. He pointed out after the publication of your report today that his decisions were validated by other instances. Thus, he claims that they were not wrong. My question to you, how much of his behavior affected Lula's rights, either politically or his private rights?
So by behavior, I suppose it's a compendious term, I guess, me referring to certain of the actions. I mean, it's just to be clear, it's some of the actions taken in the course of the investigation and in the course of the trial. I should say, first of all, in connection with the statement that former Judge Moro issued, is that the committee is not concerned with issues of guilt or innocence. So let me be very clear about that. We are not looking at the conviction of Mr. Da Silva to say he was rightly or wrongly convicted. What we are looking at is the whole process in the investigation and in the trial to see, did he have a fair trial? And we are looking at this because, of course, of the specific complaints made by the author to say, well, there were these violations of his rights to liberty and to privacy and to his, procedural guarantees. So the issue is really, we really have to ensure that we can separate out the merits or the substance, the details of the allegation, as opposed to the process. And what the committee is concerned with is this, these surrounding circumstances of the trial. Was it fair? Was the investigation fair? Now, you asked as well, how does that conduct, did that conduct impact upon him? Well, there were very concrete examples of prejudice that was suffered by the author, and this came out again in the discussion in the documents submitted, and as well accepted by Brazil's courts. So you have, for instance, an arrest warrant which leads to somebody being deprived of their liberty, and an arrest in view. It became a big spectacle. So affecting persons' dignity and their rights, to dignity. All of this in full view when you haven't considered or adopted the procedures in law. You have a conviction, in a process that is admittedly violates certain rights under the covenant. So I mentioned Article 14.1, Article 14.2 about presumption of innocence. After that conviction, the author spends, a period of time in incarcerated. Again, this is a material impact. And then, of course, not being able to run for election, which again is another fundamental political right. Yes, you lose that right if you're convicted, but he was not finally convicted. His appeals had not been settled finally. So, of course, if you this is common sense. If you were convicted and a court upholds your conviction, then you can't run for a high office or any office. But the point in this case was that he had appeals pending. And so, in answer to your question, there were instances of, where he did suffer prejudice as a result of those actions taken.
One last question, sir. With all of this that happened in Brazil and moved basically the economy, the political scenario, I would say even societal debates were generated because of all this story. What lesson should we take from this? I know it is not a legal question, but from all of this that happened in the last, I would say, almost a decade now, what is the lesson that we should take from, on one side, fighting corruption, on the other side, the strength of institutions, and on the third side, perhaps, the rights of individuals?
Sir, you've almost answered the question you asked with that very kind of clear presentation. And, I would just want to return to what I said in the beginning, because, first of all, to underline that fighting corruption is critical, and there are very real, concrete links to human rights. So it's not just an economic thing. If where corruption exists, we know that devalues a range of human rights that persons are entitled to, because money that should be spent on the society and the people is diverted. So this is clear. This is unequivocal, and I think the first lesson should be that would want to be very clear that principle, that obligation, that duty is in no way diminished by our decision. But you mentioned the debates and the very vigorous sort of civil society engagement that this thing precipitated, and that's only natural because of the office in which it was attached. Permit me first to say, sir, that to outline that the procedure of the committee is completely rigorous and impartial. In other words, The committee holds no brief for any government or any state or any political ideology. The committee is composed of 18 members representing, an equitable geographical and cultural distribution from around the world. And we are under the terms of the covenant, we are elected there because of our expertise in human rights and because of our independence from governments. In other words, no one here is a government person. So the first thing I wanted to say is just to reassure the public who might think, well, it's for one side or the other, that it's an independent committee. And we make the decision based on all the material. So when you mentioned 6 years, one of the reasons it takes 6 years is because when somebody brings a complaint, it's transmitted to the state brings their side, and we look at all the documents. That back and forth takes a while. And we analyze that on the basis of the covenant itself and our jurisprudence. So at the end of the day, all we are saying by this decision, which is based on, the underpinning is the treaty itself and our jurisprudence that deals with a fair trial. What we are saying here is that any trial for corruption and any investigation, no matter who the defendant is, whether you are a senior, whether you're a junior, those investigations and those trials must be fairly conducted, must respect all due process guarantees. And perhaps I should underline that ultimately, when you do this, if you respect all of these guarantees, make sure that the judge is impartial, is seen as impartial, that there are no public statements, there's no trial in the media, you respect the domestic law, then any conviction after that is unassailable. Then no one side or the other can say, well, this is victimization or political, this is just a partisan political move. I think so they are very, very utilitarian reasons for this, as well as human rights reasons. Ultimately, everybody must have a fair trial, and that's the human rights reason. But I think once you follow those procedures, then no one can question the outcome. And I would end off by saying, in this case, I want to stress this: the factors that this committee used to find that there were these denials of a fair trial were rooted in the decisions of the Brazilian Supreme Court itself. Yes? So, these are things that were accepted based on the conduct of the trial. And the Brazilian judges themselves said, well, this should not have happened, that should not have happened. But I know I've said a lot, but permit me just to say at the end, permit me just to reiterate that we completely accept that states have this obligation to fight corruption. All we're saying is that please, to make your processes unassailable, these fair trial rights must be respected.
Excellent. Thank you so much for all these explanations, legal explanations, but also the institutional explanation, because obviously it is a very intricate process. It is not always easy to understand from outside, but you are absolutely very clear, very transparent on the ways that this was done. I'd like to thank you very much, sir, for taking the time to talk to us. I'll just turn into Portuguese so we can conclude here. Gostaria de agradecer a todos aí por acompanhar a entrevista, uma entrevista que esclareceu justamente as principais decisões em relação ao ex-presidente Luiz Inácio Lula da Silva, ao ex-juiz Sérgio Moro, uma decisão do Comitê de Direitos Humanos da ONU, que nós tivemos a possibilidade de falar justamente com um dos peritos responsáveis, um dos responsáveis, eu diria, pelo próprio trabalho conclusivo. Dear sir, thank you once again. Hope to see you soon at some point, and have a good day wherever you are.
Yeah. Obrigado.